Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 153. Section 153 talks about the completion of the assessment, reassessment and recomputation. And in section 153 there is a provision that whenever tribunal remands back the matter to the assessing officer, then the assessing officer has to pass the fresh order within 12 months from the end of the financial year in which the order is received by the revenue. In the present case, the question before the Honorable Delhi High Court through a writ petition was that when the order will be deemed to be received by the revenue, or whether it was necessary on the part of the tribunal to provide a certified copy to the revenue to give effect to the order of the tribunal. This issue has been taken up by Honorable Delhi High Court in the case of Sunshine Capital Limited versus Deputy Commissioner of Income Tax and others, and this case is reported in 472 ITR at page number 293, and the date of the judgment is 16th April 2024. In the present case, the tribunal remanded a matter back to the assessing officer, and the tribunal sent the order of this remanding back to the revenue on 24th October 2018. But the revenue was regularly pressing this thing that this order has not been received by the revenue. The assessee also intimated the department two times, first on 30th July 2020 to give the effect to the order, and once again on 9th July 2021 the assessee provided all the details regarding the passing of the order to the revenue, but no action has been taken by the department to pass the fresh order, and till date when the assessee filed the writ petition to the Delhi High Court, no fresh order has been passed by the revenue. The assessee filed the writ because there was demand pending on the ITBA portal. When this matter was heard by the Honorable Delhi High Court, the court said that in the present case no concrete steps have been taken by the revenue and no measure has been taken to give the effect to the order of the tribunal. The court said that the revenue in the present case has to pass the order within the 12 months from the end of the financial year in which the order is received, and the language which is used in section 153 is similar to the language used in section 260A. The court said that the phrase used is received in section 153 postulates that date should be taken as received when the order is pronounced in the open court and it comes to the knowledge of both the parties. The court said that the intent of section 153 is not to shift the burden of proving that the order is being received by the revenue, and the court said that section 153 does not mean that it gives the power to pass the order in a very long period or without any time limits. The court said that section 153 should not be interpreted in a way that a certified copy is to be provided by the tribunal to the revenue, and the provision cannot be read as detriment to the assessee. So in the present case, since the revenue has not passed the order, so now the time limit has gone, so the court deleted all the demands of 34.7 crore rupees and the penalty demand of rupees 33.98 crore rupees, and at the same time ordered the revenue to give the refund of 25.44 lakh with interest to the assessee. The court also ordered for the release of the property of the assessee and for the defreezing of the bank accounts. Friends, this is a very welcome judgment, because the laziness on the part of the department is not only bothering the assessee, but this much of the revenue lost to the department only because the inaction of the revenue creates a question on the working of the whole administration system of the income tax department, because non-passing of the orders can cost the department like nothing. At the end of this video, once again I am repeating the name of the case. The name of the case is Sunshine Capital Limited versus Deputy Commissioner of Income Tax and others. And this case is reported in 472 ITR at page number 293. And the date of the judgment is 16th April 2024. Thank you, friends.